Does this have an impact on the employers? It's no, there's going to be no major impact on the employers on this aspect. To whom will this judgment be applicable? To those who have been members of the prominence scheme prior to 1914, which will certainly be, and after 1914 also people could have opted for a higher pension, but only a certain category can become members after 1914. And if your employer, or if you are the employer and you have restricted the contribution to 6,500 or 15,000, then again it will not be possible. So what are we then looking at as sorry, I'm just having some issue here. So in a case where the basic salary of the employee is 40,000 and the employer contributes 4,800 to it, the employee contributes 4,800. So this is what happens if your PF salary is 40,000. Out of this 40,000, 4,800 of employer's contribution, the entire amount goes to Provident Fund. Out of the employer's contribution, 1,800 is the mandatory contribution on the ceiling of 15,000. So of this, what happens? And the remaining goes into a voluntary contribution of 3,000. Of the 1,800, which is the mandatory contribution of the employer, automatically 1,250 goes towards pension. So there is no issue on that aspect. The remaining out of the 1,800, 550 goes to Provident. In the employer's side of voluntary contribution, nothing goes to pension by default. The contribution goes towards Provident Fund. The entire 3,000 rupees goes towards Provident Fund. So this is how the default system, pension system works. This is the manner in which the contribution goes to pension. So if we have to go by this, what happens? We have capped the ceiling at 15,000. So the member's pension, what will be the amount is 15,000. Let's assume the service is 25 years of service and the parameter given is 70, and therefore 5,357 would be the pension of the member. So this is how the scheme works by default. If you go, I'll just go back once again. So where the contribution is only on the mandatory contribution of 1,800 alone, 1,250 goes to pension, then this is how the pensionable salary, if a person completes 25 years, will be calculated. This is the, but there is also an option of the employee opting for, even in the voluntary contribution, some part going to the pension. So in the earlier slide, what we saw, so the voluntary contribution of 3,000, the employee can say out of this 3,000, which is a voluntary contribution by my employer, 8.33 should go. So this 2,083 rupees would go to the pension fund. So if you had seen the earlier slide, the entire 3,000 went to Provident Fund, but now additionally 2,083 goes to the pension fund, 917 only goes to the Provident Fund, not the entire 3,000. So what happens then? Where an employee was getting 5,357, the same 25 years of service, the employee will get 14,285. So nearly 2.8 times jump would be there in the pension. So as the amounts increase, so if somebody is getting 70,000 as the last round, if they had put in 35 years of service, that is 33 is the maximum plus 2 years of addition that they give, 35 years of service, they will get 35,000 rupees as pension. which otherwise it would have been only 7,500, but this will be 35,000 rupees. As you go up higher, if it 1 lakh is your last round, pensionable salary, which is a 60 months average of your last 5 years service, then your pension will be 50,000 a month, vis-a-vis 7,500. So this is the manner in which the pension can exponentially increase if you were to contribute on a higher portion towards pensionable, towards the pension scheme. So where do we get this? What happens is, under the pension scheme, as and when the ceiling, you exceed the ceiling. This is what was the question in the earlier judgment of R.C. Gupta. So for determination of pensionable salary will be limited to 6,500, provided an employee opts for a higher amount. So this is an earlier provision. 6,500 was the cap. That case pertained to the ceiling of 6,500. So you need to exercise an option. So the employee should exercise saying, I want from the voluntary contribution also some portion, 8.33, should go towards the pension scheme. In such an event, you get to this higher pension that I was just trying to tell you. So in R.C. Gupta, what the Supreme Court said was, yes, you can opt for it. You can opt for it at any point of time. There is no time limit that has been prescribed for jumping into the higher pension. So as and when you start to contribute on a higher salary, so beyond the ceiling of 6,500, if the employer has been contributing, then you can make this option at any point of time. So this judgment, of course, came in 2018, R.C. Gupta judgment, but it started way back when the ceiling was 6,500. This judgment was implemented by the Provident Fund, but then they realized that implementation of this judgment would mean that there will be no funds, EPFO excess funds that is there currently, all the unclaimed that is there with the Provident Fund, all this would be wiped out in no time. At the same time, or rather before this judgment came itself, in 2014, certain amendments were made to the pension scheme. So if you were to retire, normally they were taking only your last 12 months. So if you retire in December 23, they will take what is your salary from January 23 to December 23. But now they said it is going to be 6 months, 60 months average. So they will be taking your salary 5 years before. So 23 means 22, 21, 20, 19. So starting with your January 19 salary, they will start. So 19, 20, 21, 22, 23. So 5 years salary they will take. They will divide it by 60 months, whatever is the total you arrive. And that will be taken as your pensionable salary. That into the number of years of service divided by 70 to arrive at your pension amount. So instead of 12 months average, they take 60 months average. As a result, your pensionable, the salary that is reckoned for pensionable salary itself comes down. So that was one amendment. Supreme Court has said, yes, this amendment is correct, you can do it. Then they increased the ceiling from 6,500 to 15,000, which they did for the Provident Fund and pension. Then they said, whoever becomes new members under the PF scheme, and if there are excluded employees, that is, if their salary at the time of joining the PF itself was more than 15,000, they will not be enrolled into the pension scheme. Supreme Court has said, yes, this amendment is also correct. Then they said, whoever has already opted for a higher pension should exercise one more option within 4 months. And then about a contribution of 1.16 given by the government will be restricted only to the mandatory contribution. On the voluntary contribution, government will not make any. So I'm not going to touch on this last topic because that's not too relevant today. What we are now looking is only for the higher pension, what employers and employees will need to do. So what is the judgment? So this question, so this amendment was tested before various high courts. Many high courts struck down these amendments to some extent, to whatever extent they were tested, they were all struck down. So the Provident Fund Organization filed appeals against the orders of the High Courts, and also the Provident Fund filed a review petition against this judgment, the R.C. Gupta case, where Supreme Court already held you can exercise an option for higher pension at any point of time. This judgment also they wanted a review. They also took appeal against orders of various high courts where they struck down certain provisions of these amendments. So all this went to Supreme Court. That is the judgment that the Supreme Court has rendered on 4th November 22. Now we shall go only on the aspect of pension and the exercising the option. I am not going into the other aspects of the judgment. 44.3 of the judgment, paragraph 44.3 reads, employees who had exercised option under the proviso to para 11.3. So 11.3 is the prior to 2014. This is the 11.3 which I had showed you earlier. And continue to be on service on 1st September will be guided by the amended provisions of paragraph 11.4 of the pension scheme. That is 11.4 is the new amendment that they have brought in. This is one. I will elaborate on this slightly later. Please just take note. This is 44.3. In 44.4, they say members of the scheme who do not exercise option as contemplated in proviso to para 11.3 of the pension scheme, that is before the amendment, would be able to exercise an option under 11.4 of the post-amendment scheme. The right of option before 1st September stands crystallized in the judgment of this court in the case of R.C. Gupta. The scheme as it stood before 1st September did not provide any cutoff date. Thus, those members shall be entitled to exercise option in terms of para 11.4 of the scheme as it stands at present. Their exercise of options shall be in the nature of joint options covering pre-amended para 11.3 as also 11.4 of the pension scheme. There was uncertainty regard to the validity. Therefore, they grant ultimately in this right-hand side what you say, they grant 4 months time. So that is the time that's now clicking, and therefore before 3rd of March you may need to exercise the option. So this judgment, para 4, the 11th, the left-hand side that you see on your screen, this is what is important for many of you. Then we will come to 44.5. The employees were retired prior to the 1st September without exercising any option under para 11.3 of the pre-amended scheme have already exited from the membership thereof. They would not be entitled to benefit of this judgment. And in 6th, they say, employees who retired before 1st September upon exercising option under para 11.3 of the shall be covered by the proviso to para 11.3 of the pension scheme as it stood prior to amendment of 2014. So we have these 3, 4, 5, and 6, which are 4 subclasses of the judgment, paragraph 44.3 to paragraph 44.6, which is the issues for the pension, higher pension option is concerned. But the most beneficial observation for employees is in paragraph 44.4. So they say the judgment of R.C. Gupta is correct and it has already been crystallized. What does R.C. Gupta say? R.C. Gupta says you can exercise the option at any point of time. And anyway, in this judgment, they have given option for exercising the option for a further period of 4 months. So now we will see what has happened. There is some very slight contradiction, but that is only in respect of those who retired prior to 1914. And this part, PF has also issued a circular. So I don't think, so we now need to split this judgment into 2. Those who retired prior to 19/2014, those who have retired or retired after 1914 are still in service. As far as those who are before 1914 is concerned, Supreme Court says if they have already exercised the option and it was rejected, then they alone will be able to exercise an option because they've already a right has crystallized in their favor. But in respect of those who have retired without exercising, they say this. In one part, they say it can't be done, but in one part, they say it can be done. Why do I say that? Because R.C. Gupta has been upheld by them. R.C. Gupta says you can exercise that option at any point of time. So, but in any event, what now flows down is they have split the judgment into two. We need to see it into two. Those who retired before 1914, those who retired after 1914. Those who retired after 1914 or continue to be in service after 1914, they have a much clearer case because in terms of para 44.4, they can exercise the option even now within 4 months. So that is where we are now looking into these aspects to see what has to be done. So there are two aspects. Questions come, what should an employer do? What should an employee do? As far as employers are concerned, they will need to just sign a joint declaration form and give it to the employee for nothing more than that to start with. That will be the starting point. Later on, maybe if you're a private trust, you run a trust, the trust may be asked to transfer some funds. But as far as the employer is concerned, all they need to do is do a joint declaration to the effect saying that a higher pension was paid, rather higher contribution was made beyond the ceiling for this employee. That joint declaration alone would need to be given by the employer in terms of the judgment of the Supreme Court. As far as employees are concerned, those who retired before 1914, their cases are more restricted. There is a Provident Fund notification to this effect. So those persons alone will be benefited. That is, those who applied before 1914 and the PF authorities rejected, they alone will get benefits. Then we come to employees who retired after 1914 or are still in service, having joined before 1914, they are still in service. These persons would need to exercise an option, this joint declaration, and they can just send it to the Provident Fund organization. So the question may come, should we employee send it, employer send it? My suggestion would be employees sign and send it. There have been news items in the last 2 days saying that PF has been asked to work on it. Ministry has been behind PF to do something because the timeline is going to expire. So well and good if they do, that's good. But even if they don't, my suggestion to employees is to make the joint declaration so that at some point you may get the benefit. So this 4 months cutoff date, if you literally take 4/11/22 will be 3/3/23. So whatever has to be exercised would need to be exercised before this date. So many ask what happens, will PF extend it? My honest view is this judgment per se, the liability flowing out of this Provident Fund may not be able to take it up. It's a very big liability. Over a period of time, it is going to pinch the PF very badly. One, either government has to step in to fund the Provident Fund up to the deficit, or somewhere there will be amendments that are brought into the PF Act with retrospective effect. So, but immediately are they going to grant it is a big question. We need to wait and see. So next is if they're not going to, and why are we doing it? The question is sorry, just 1 minute. As I said, the judgment splits the pension persons into two, before 1914 and after 1914. The judgment has given relief to everybody who continued after 1914. Whether they retired after 1914 or they are still after 1914, all these persons can make an option within 4 months. The Provident Fund organization, for their own benefit, may not interpret this judgment. We don't know if they are going to act on this paragraph 4, that 44.4 that I just displayed. But a safer approach would be for employees to make the joint declaration today before 3/3. Later on, even if Provident Fund says, no, we are implementing, but only to those who gave within 4 months. So we don't know, you may lose out at that point of time. So it is better that employees make an option today and take a chance. As an employee, what is required to do? Employees are required to get a joint declaration from the employer and send the joint declaration, maybe with a covering letter, through registered post to your Provident Fund organization, wherever, whichever office they are enrolled. There's nothing else that need to be done at the moment, because PF has not come out with any kind of clarification. So just to send the joint declaration. Where do I get a joint declaration? Joint declaration PF is given in respect of those who retired prior to 1914. So appropriately modify the same joint declaration and you can use it. As far as employers are concerned, we cannot say that this higher pension is everybody's cup of tea. There could be somebody who feels his longevity is not going to be much. So if I retire in 58, I feel I will not survive beyond 60. So I would like full pension. I would like a PF rather than pension. Or somebody may think I'm very good at mutual funds. I will put the money into PF, take it out, and I'm not bothered about a monthly fixed amount coming to me. But generally, to a larger extent, pension is a better option. So employers, if they so desire, can, only suggestion here, give a communication, just put up a notice to employees explaining, saying there is a judgment. If you can exercise before 3rd March, you may get a higher pension from PF. You cannot commit, there's no liability on you, but still it's better you don't commit on it. But more on an information part, if you could share with your employees, either by emails, notices, or communications, and bring it to their attention that such a judgment is being pronounced and it could be of use to employees. As I said, as things stand today, PF has not accepted the judgment for those who retired after 1914. They have not come out at least with any kind of a notification for those who retired or served after 1914. So we don't know what it is, but the judgment per se, if you were to read, you will be entitled for a higher pension. This point I already tried to explain, saying that PF today has not taken a definite stand, but later they could take a stand, or Supreme Court in a contempt proceeding or something could say their understanding of law is right. Those after 1914, they are eligible. That is our direction. You should obey. At that time, they shouldn't say, no, you gave a 4-month time. Supreme Court gave a 4-month time, and that 4 months time, the employee did not. So we will honor the judgment of the Supreme Court only for those who gave an application within 4 months. It's only in that aspect it is suggested that you employees give a joint declaration and make an application before 3/3/23. Already I tried to explain, joint declarations being given in respect of those who retired prior to 1914, can make appropriate modifications to it and send it to the Provident Fund organization where your last employer is registered. So if somebody is out of Chennai, somebody is out of Coimbatore, somebody is out of Delhi, you just need to send where your last employer, with which PF office he was registered, please send it to that address. And it is better for the employees to send it and keep records rather than employer, because the pension is going to be their individual rights, and employers may also find it difficult to maintain these records. So it may not be wise for employers to take it. The employees can sign it, send it, and maybe they can mark a copy to the employer, and the employer can retain a copy of it. But the primary source, let the employees send it to the Provident Fund with registered post to keep record of this. This has also been answered. You just need to give a joint declaration as said already. You need to make a joint declaration if this is your case. Supreme Court says this they have restricted. So those who retained before 1914 has been restricted to only those who had already applied and not to others. But whether this the judgment says even those who retired before 1914 can also apply, but it is also trying to restrict only to those who had already made an application. So we need to wait for, there is an ambiguity only in respect of those who retired before 1914 alone. Wherever the contribution has been only to 6,500 or 15,000, this judgment will have no application whatsoever. This is a question which is important not only for employees, but employers should also be aware, because the many employers have contributed despite employees not being eligible. So if you join beyond the ceiling, so 15,000 is the ceiling, I become a member for the first time after 1914 and my PF salary is more than 15,000, I cannot become a member of the pension scheme. If an employer by mistake has made any employee as a member of the pension scheme and has paid contribution to the pension scheme, it needs to be run, redone, revised returns needs to be filed to correct this anomaly. And these persons will not be eligible at all to become a member of the pension scheme. So I think others, I've covered to a great extent. Yes, when you exercise an option, there will be a reduction in your provident fund because part of your employer's voluntary contribution is going to be taken for pension, whereas currently it was taken for provident fund. So when it is taken off, provident fund will, when you withdraw your provident fund at 58 or 60, there will be a reduction, but your pension will be much more higher depending on what your last round salary is. For a higher pension, those who feel they want a higher pension, they need to exercise this option. So this is all we have to present on this because of many queries that came about on this aspect. If there be any queries, I'll be glad to answer. If you just lift your hands and we could go one by one.
If you can flash the email ID once again, it would be nice.
Good morning, sir.
But if you can flash the email ID once more, it would be nice of you.
We will just post it in the chat box. Is that fine?
Okay, right. In the same email that what we are written now?
Yes.
Okay, thank you, sir.
From the Provident Fund authorities, they are not accepting the joint declaration and they are saying we are not got any instructions from the EPFO. What should be our approach with them, sir?
As I said, yes, that's going to be their approach for now. So it is better, but still to make the application and the employee can send it. The employers don't need to get into this at all. Employers will merely sign the joint declaration and give it. Let the employees send it. So today they may be saying they cannot, but then the Supreme Court has asked them to do it, and therefore at some point of time they would accept. They would be forced at least to accept it. at that point of time, you will have better a position, especially employees. If later on the same Provident Fund may also say, no, you should have applied before 3rd March, you didn't apply. So having not applied, we are not going to extend the benefit of the judgment to you. So therefore, it is better some application is made, let the employees send it by registered post and let them retain it themselves. You don't need to get involved as an employer.
Sure, sir. Thank you, sir.
Mr.
Yes, Ms.
Anand,
Mahalakshmi.
yeah, okay.
Morning,
I'll
sir.
just come back to you.
Morning, sir. Mahalakshmi, I just have one doubt. See, as per the 2014 amendment, pensionable salary now is calculated based on the average of 60 months. Is that the current practice which is followed, or is it the last drawn multiplied by the number of years divided by 70?
Sorry, the act says 60 months, last 60 months should be taken. So you're now, every month when you upload, the gross salary, pensionable salary is also uploaded. So the pensionable salary of last 60 months is taken, averaged out by 60. I mean, you total it, divided by 60, that is taken as the pensionable salary. That is divided into the number of years of service and divided by 70.
Okay, thank you, sir.
Hello.
Sir.
Mr. Anand,
Yes, Mr.
this is
Meghnad.
Meghnad from BBC. Yeah. See, there has been a confusion in terms of the calculation of the pension. Though you also said they take the last 6 months average salary, but even now, if you look at, I don't think they calculate based on that. But if they calculate that, no, see, now 15,000 rupees has been the pensionable salary since 2014. If someone retires now, say for example, if someone is retired in the month of January, obviously he would have contributed from 2014 onwards, so it would be 60-month salary. So in that case, average will be 15,000 rupees. But if you calculate 15,000 into 25 years minimum service divided by 70 report, it comes to 5,350. But I don't think any pensioner gets more than 4,300 rupees as monthly pension. So what I understand, even when we interacted with PF officials, they said they divide into two parts. Before 1/9/2014, there's a separate calculation. They were taking 12 months average salary. Then now they are taking 60 months average salary. I think they also follow this, and they have two separate calculation, part A, part B. Then they add and they come out with a kind of pension, I believe. Because otherwise, if we go by this 60 months average salary, even now it is not coming to that. It is not matching with that formula. This is my and moreover, since people are retired and they are kind of confused. See, the pension amount which will play a major role in terms of taking a decision about this, because they'll have to shell out a huge money since they retired people. They've already invested somewhere, and now they'll have to take out they have to break their FD and go for this higher pension. So unless they get a clarity about the pension calculation, are they likely to be the amount as pension, so this they won't be able to take a call. So if you can just clarify on this, then it will be better for us then.
See, no, the way they calculate, I can't do much about it, but the law provides it only should be 60 months. But you're right, that's how they are doing it. So the calculation aspect could be wrong. But there have been also cases where they don't restrict to 4,300. I think even in your own company, there have been people who were, after the judgment, for some they were revised and a higher pension was being paid. So in any event, there's nothing much for you to lose today by giving a joint declaration as of now. So if you give a joint declaration today, and once the law is settled, you're going to get a higher pension, and only if they are going to accept the judgment. Only if when they come to the position of accepting the judgment, a part of your pension from the employee share is going to move to the PF share. So till such time, they may also not disturb the contributions. Contributions are going to remain as they are. Therefore, I think some point of time, this higher pension will become, yes, it is a huge liability. We don't know how PF is going to handle it. In fact, PF, that's one of their contentions before the Supreme Court was, we cannot, this judgment and its impact will erode all the contributions. But Supreme Court said that's the law. We are only here to interpret the law, and we are not to see for your financial burdens. and they have interpreted the law. So therefore, we need to see what happens on the contribution. But as I said, the parliament can always amend with retrospective effect and nullify this judgment. But as on date, this judgment stands, and it is better for persons to make an joint declaration at this part. Mr. Bhaskaran Natarajan, please.
I have
Mr.
one more
Bhaskaran?
question. This is Basaraj here.
Mr. Manikantan?
Good morning, sir.
Good morning.
Sir, we are approaching PF department regarding the persons who got retired after 2014, sir. They are telling that their software is under preparation, wait for some time. Likewise, they are telling, sir. So in this situation, if we send a lot of joint declaration from quoting our company number, they will get antagonist, So it is a kind of indirect invitation for some kind of audit, some kind of thing.
You're talking as an employer. Can I take it?
As an employer, you can take it. As an employer.
Yeah. So as an employer, that's why I said you don't send it, let the employee send it. You only sign the joint declaration and give it. See, it's up to you. If you, I'm not, see, all these are only suggestive. We know that the cutoff date is 3rd. And tomorrow, if the same PF says, sir, when did we tell you not to send it? You could have sent it by registered post. What are you going to go tell your employees at that point of time?
Okay, sir.
So it's better to be safer, and it's especially for employees' benefit. It is not for you that you get anything out of this.
Okay, sir. Yes.
Ms. S. Kumari.
Good morning, sir.
Morning.
This workings we have to do with retrospective or prospective, sir. I give a joint declaration.
All that is later on. Today, for now, just give a joint declaration. That's all they're asking. They're not asking for any kind of working along with it.
Okay. Okay.
Later on, they will come back. Once they accept, all these things are going to come. Today, we are only looking at, of course, workings will be retrospective. You need to do for past periods.
Okay.
Unless you can't see when, if your salary, there are a lot of cases. I worked with an employer between 2003 and 2008. That employer paid beyond the ceiling limit. Then between 2008 and 2015, I worked with an employer who paid only up to the ceiling limit. And then we have cases where I again came and worked with an employer who paid me on the entire salary and did not restrict. These kind of employees may not be eligible at all. So who is going to be eligible is from day one, his salary crosses the ceiling until the date of his retirement. If contribution is being paid over and above the ceiling limit, all those employees will be entitled.
So you mean to say the workings part, we can take care of it little later. The first priority is to give a joint declaration. Those are eligible for giving the joint declaration.
Yes.
And that has to be completed by 3/3/2023.
23.
Yeah. Thank you, sir.
Just to stop here for a minute, a short PPT that we just made. There is also an elaborate note that we have prepared. And we are also making a kind of a joint declaration that is suggestive, and also a communication that employers can send to their employees on this aspect. Along with the R.C. Gupta judgment, the earlier judgments, and all these things, we will just try to put it into a G drive so that all participants who have access today using their email address that you use today to log in, you can use that and you can access those documents. So the joint, if you want a format for joint declaration or what communication you need to send to your employees, you will be able to get it from there.
Sir, good afternoon, sir.
Yes, Mr.
Yes. Sir, shall we suggest to current employers to submit that joint declaration for higher pension, sir?
Yes, the last employer needs to do it. Last or current.
Thank you, sir.
Hello. Hello.
Yes, Mr. Kannan.
Yeah, hello. Two questions. One is what are the documents the employer should provide to the employees when we make the joint declaration? That's question number one, because the way PF has asked for the one prior to 1924, the retirees, they have put a lot of documentation on the part of employer to submit on their own life. So in this case, what are the documents as employer one should be ready? That's question number one. Question number two.
If I could just answer that alone, just 1 minute, I'll answer that first. So as far as your first question is concerned, PF today is not even recognizing this group after 1/9/2014. There is no forms that they are given. They have not asked for anything. So it is only for, we don't know, maybe we are talking today on Saturday, by Monday, they may issue some communication after the Labor Ministry appears to have put some pressure on them yesterday. So something could come out in the next few days also, we don't know. But if nothing comes about, all that is going to happen is the joint declaration signed by the employer and employee being sent by post. That's all is going to happen. And they have not asked for any documents. So therefore, for now, just send the joint declaration. Nothing needs to be attached for now. All the attachments can wait. Let them come back and they will start asking. At that point of time, you can see what is the attachment, what is the workings to be given. For now, just one joint declaration, maybe with a covering letter by the employee asking for a higher pension. That's all. Yeah, second question.
Second question, I hope the employee has got the choice. What's the amount, the basic salary he or she could apportion for pension? I hope it is not that either it's black or white kind of a situation. The employer has got the choice. What's the apportionment he can decide?
To what portion is it?
Yes. I mean, if the
So if your question is, if I just please tell me if I got it right. My salary is 45,000. On 15,000 already contribution is gone. I don't want on 45,000. I want only on 15,000 alone to go. Is that your question?
No,
so rather 30,000.
Yes.
Not on 45,000. I don't think that option is available. I don't think their system or anything allows that kind of. You need to do only on the entire 45,000.
Okay. This is useful.
Technically speaking, what you say is possible, but I mean legally speaking, but technically I don't think it's going to happen.
Sir, who should be the authorized signatory from the employer side for the employee from an organization? Should it be the company secretary or should it be the PF authorized signatory?
Yeah, PF authorized signatory should be good. Whoever has been authorized and who's already signing your monthly challans and things, that is a good person to do.
Okay, thank you.
Sir, good morning. This is Babu.
Yes, Mr. Babu.
Yeah, sir, already nominee is getting the pension. Okay, the employee is no more. So the nominee can apply the higher pension. The employee is eligible for that.
Yes, certainly. Yes.
Sir, once again, where
if after 1914, it is fine.
Okay, sir. Yeah, thank
you.
Mr. Prem Kumar.
Yeah, so just one clarity. So you said that both employer and employee should make the joint declaration they should make. But organization like spread across India, because very short time is there to collect all the forms, get it signed. Is there any possibility when just employee sends a declaration directly without employer signature? Because short time is very, very short now.
That may again they will reject it on some technical ground if they want to. So it is a joint declaration. It is meant to be a joint declaration. So I don't think today that short time is going to be a. You may need to work on it. Maybe authorize others also to sign it in each location or something. Get somebody responsible to sign it.
Okay. Okay, sir. Fine. Thank you. Thanks.
Hello, sir.
Samir?
Yes. Sir, I just want to understand how the pensionable salary will be considered. Suppose I have joined in 2001 with a higher pension, more than 6,500 contribution. At actual salary I am contributing and still I am working. I will be retiring in some 2033. So they will be calculating from 2001 to 33 or it will be from 2014 to 33.
I'm sorry, no, they will, your 2001 to 33 will be reckoned for pension. So that will be like 22 years of service. And strictly speaking, going backwards, 33 when you retire, 33, go back 5 years, 27, 28. What was your salary in that 60 months will be taken, and that average of that 60 months salary into these 22 years of service divided by 70 will be your pensionable salary.
Plus 20 years, you get 2 years benefit, right?
Sorry, Mr. Soni, I can't hear.
More than 20 years, two years will be added.
2 years, yeah.
Okay. Okay, clear. Thank you. Service.
Yes, Mr. Andrews.
I tell you, once again says where to access those documents. You said if you have an email ID, you can.
We will send you. We'll send you a link to each of these emails that you have used to register today. To that, we will send you an email.
Okay, thank you, sir.
Sir, one more basic question. We have a private trust, and those who got retired after 1/9/2014, we have settled their PF amount. Okay, only this pension amount is going through regional PF office. In that case, if they give a joint declaration, how to do the allocation between this PF and pension, sir? Because it is already settled to them.
The earlier judgment, when it came in 2018, they were allowed to repay the money to the Provident Fund with interest, and then pension was being sanctioned.
Okay.
So that is again the headache of, they will ask you for declaration, but the allocation and what is to be repaid and everything, PF will work it out. It is not for your trust to do it.
Oh, okay. So if the employee gives a joint declaration and PF authorities will give me the amount, what the employee has to, that the ex-employee has to pay to the trust along with the interest.
Yes.
Correct, sir. That amount I have to pay to the PF authorities, and in turn PF authorities will pay as a pension amount.
Correct.
Okay. So in that case, this 3/3/2023 is the deadline for not only the live employees, but also those who have got retired between 1/9/2014 and till date.
Yes.
Okay. Thank you, sir.
Hello, sir, Bhaskar, sir.
Yes, Mr.
Hello, sir. I got.
Yes, sir.
Hello, I actually I'm Bhaskaran. Hello, sir. Are you able to hear?
Yes. Yes, sir.
So I retired 2013. As per the circular of PF in 2017, I got